Hello, I am Michelle Uzetta. I'm a senior counsel at the Disability Rights Education and Defense Fund. DREDF is a nonprofit national law and policy center focused on the rights of people with disabilities. We are also funded to provide support to qualified legal services providers in California. And as part of that mandate, we do trainings occasionally on things. A couple of housekeeping items that Diana didn't touch on, or maybe she did and I just didn't hear her. MCLE credit for this presentation is still pending. So as soon as we get the paperwork for that, we will send it around to folks. We anticipate that it'll be approved within the next week or so. Also, the materials, this PowerPoint, I will make sure that it gets emailed to everybody after the presentation. And I believe we have a sign in or a survey that Diana should link to at some point during the training. And with that, let's get started. I do want to encourage, because I know I saw the registration. I know that there's a lot of people who registered for this presentation that are already familiar with fair housing law. And this is kind of a basic fair housing training. I encourage people to use the chat, to share information that maybe I don't cover, or to ask questions of each other. Please use the Q&A for questions that you're hoping we have time to answer at the end of the presentation. So I think we have close to 200 people on this webinar, or at least that had signed up. So we may have a large number of people participating in the chat. I'd like to get a sense of who's here. So using the chat, if you could just let me know if you're an attorney, an advocate, a housing provider, a tenant, or something else, that would be great to know. We have a couple of learning objectives for today's presentation. The first is to understand the basics of the Federal Fair Housing Act. And I do have a few slides on California's Fair Employment and Housing Act, although I know that there's people from other states who are also participating. Diana, I'm getting messages from folks that the chat is disabled. If you could enable the chat for everyone. I will be asking people to use the chat during the hypos too, so that is important.
Is the chat working right now? So please, perfect.
Yes,
Thank
there
you.
we go. Thank you, everyone. The second learning objective is to understand fair housing rights and responsibilities. And the third is to understand complaint and enforcement processes. First, I wanted to talk a little bit about why fair housing protections are important to people with disabilities. The first is that due to low wages and inadequate supplemental security income, renters with disabilities are often priced out of housing at rates higher than that of the general population. Less than 5% of housing nationwide is accessible for people with moderate mobility disabilities, and less than 1% is accessible for wheelchair users. In 2020, 42% of people experiencing homelessness in California reported having a disabling condition, which includes everything from physical, mental health disabilities, HIV or AIDS, or other illnesses, including people who became disabled due to military service. And according to data from California's Civil Rights Department that enforces the California fair housing laws, the most cited basis for discrimination in housing is disability. In 2020, disability complaints made up almost 40% of all the housing complaints filed. So in other words, the right to be free from housing discrimination is essential to the goal of independent living. And this is a quote that came from the legislative history of the Fair Housing Act. So the Fair Housing Act has been around since 1968. The general policy articulated by the Fair Housing Act is that the United States should provide fair housing to everyone. The first 5 protected classes that were recognized in the 1968 Fair Housing Act were race, color, religion, national origin, or the first four rather. In 1974, the act was amended to add sex. And then later in 1988, there were amendments that added familial status and disability. And we're focusing on disability today. So the Fair Housing Act defines disability as a person who has a physical or mental impairment that substantially limits one or more major life activities, or a person that has a record of such a disability or is regarded as having such a disability. And where you see cites in these slides, it's to the definitions. Some common examples of physical or mental impairments that qualify for disabilities under the Fair Housing Act: folks that are blind or low vision, deaf or hard of hearing, things like muscular dystrophy, cerebral palsy, HIV infection, autism, schizophrenia, cancer, epilepsy, or individuals in recovery. Now, this is not an exclusive list, and the definition of disability does not include folks that are currently using illegal drugs or sex offenders. The term major life activity includes things like caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, or walking. And again, this is not an exclusive list. There is a direct threat exception under the Act. So someone determined to pose a direct threat does not benefit from the Act's protections. And the Fair Housing Act defines direct threat as something that constitutes a direct threat to the health or safety of other individuals, or would result in substantial physical damage to the property of others, unless the threat can be eliminated or significantly reduced by reasonable accommodation. We'll talk about reasonable accommodations in just a couple minutes. So how do you determine what constitutes a direct threat? Well, the regulations provide some guidance on this. When determining whether someone poses a direct threat, you have to do an individualized analysis and consider the nature, duration, and severity of the risk or injury presented, the probability that the injury will actually occur, and you have to look at whether there are any reasonable accommodations that will eliminate the direct threat. You should also consider whether the individual has received intervening treatment that has eliminated the threat. In other words, does the significant risk of harm still exist? Direct threat cannot be based on general assumptions, subjective fears, or speculations. So as an example, I had a situation where a tenant was noticed for eviction for talking to himself in common areas. A number of other tenants had complained to management that they found the individual to be scary and threatening. We were able to push back on that assumption. There was actually no significant risk of harm in the situation. The tenant did not bother anyone. There was no history of any kind of confrontation or physical attack. This person was talking to themselves, not directing the conversation to other people at all. So when we looked at the situation and conducted the individualized analysis, there wasn't enough to constitute a direct threat. We were able to avoid any kind of adverse housing action. The next couple of slides illustrate the broadness of the Fair Housing Act. As a remedial statute, the Fair Housing Act is both written and interpreted broadly to achieve its purpose of combating discrimination and ensuring equal access to housing. So this first slide shows that the Fair Housing Act applies to a wide range of real estate transactions. So the FHA prohibits discrimination by direct providers of housing, such as landlords and real estate companies, as well as other entities such as banks, lending institutions, insurance companies. All of these folks need to avoid discriminatory practices and make sure that housing is available to people regardless of disability status. So it includes situations like rental, sales, lending, insurance, zoning practices, and actually all areas connected with residential housing. The entities and people that are covered by the Fair Housing Act are also quite broad. Includes owners of housing, managers, HOAs, lenders, real estate agents, governments, builders, engineers, and the others listed here. The FHA's definition of dwelling, it's generally defined as a structure or portion thereof that's designed or intended to be occupied as a residence, including vacant land that is to be used for construction of residences. Some examples of the dwellings that are covered include private and subsidized properties, single-family dwellings, duplexes, multifamily buildings, things like nursing homes and assisted facilities, temporary shelters, group homes, migrant housing, and then university housing as well, or other residential housing, basically anywhere where people live and have an expectation to return to live. Oh, I should go back. Sorry. I did want to note that many of these examples of dwellings may be covered by all other anti-discrimination laws. For example, subsidized properties receiving federal financial assistance may also be covered by Section 4 of the Rehabilitation Act. University housing is also covered by the Americans with Disabilities Act, depending on who operates it. And these other federal laws may provide different or additional rights. So that's something to be aware of when dealing with housing discrimination cases. There are some exceptions to fair housing coverage. The first is the owner-occupied dwelling of 4 units or less, which is commonly referred to as the Mrs. Murphy exception. And then also any single-family home that is sold or rented by an owner, provided that the owner does not own or have an interest in more than 3 such homes, and that the home is sold or rented without the use of a broker, agent, or salesperson. And even then, it should be noted that the prohibitions on discriminatory advertisements will still apply to those exceptions. Prohibited practices under the Fair Housing Act. You'll note in the right corner, there's a citation. These are all listed there. The refusal to sell or rent, discrimination in terms or conditions, for example, requiring somebody with a disability to give you medical records before you agree to rent to them, or requiring excess deposit for someone who uses a wheelchair because you imagine they may be damaging the walls or the floors. The Fair Housing Act also prohibits making or printing or publishing notices or statements that indicate a discriminatory preference. For example, an ad that says no wheelchairs or active seniors only, no dogs, even service dogs, anything that a reasonable, an ordinary person would read and think, well, that doesn't want me here, and I'm a person from with a protected characteristic, would be discriminatory. Falsely telling somebody that a dwelling is not available based on their membership in a protected class. Steering people away from particular neighborhoods or types of housing based on their protected status. Discrimination in real estate transactions, brokerage services. Then also things like coercion, intimidation, threats, or interference. There are some prohibited practices specific to people with disabilities, including the refusal to make reasonable accommodations and the refusal to let a person make reasonable modifications to their housing or common areas at their expense. Well, first, let's discuss reasonable accommodations. Reasonable accommodation is a change in a rule, policy, or practice or service that is necessary to allow a person with a disability equal opportunity to use and enjoy their dwelling. Some examples include an adjustment of the rental due date to accommodate the date that someone receives their public benefits, allowing someone to transfer to a quieter unit because noise aggravates his or her disability, and waiver of no pet policies to accommodate service dogs or emotional support animals. Reasonable modifications are physical changes to a dwelling or common area and include examples like installing grab bars in bathrooms, widening doorways, lowering kitchen cabinets, adding a ramp to make an entrance accessible, altering a walkway, or things like installing blinking doorbells or emergency alarms for people who may be deaf or hard of hearing or blind. Who pays for the reasonable modification really depends on the type of housing involved. In public housing, the cost would shift to the provider of the public housing. If you're in private housing, generally the obligation to pay for the modification falls on the tenant. And then if there are modifications done, restoration may be, but is not always required. The only areas that a housing provider can insist upon restoration is in the unit. If there's modifications to a common area, for example, if there is a ramp installed so somebody can reach a public or a common area laundry area, you wouldn't have to restore that upon move out. But if you made modifications to the interior of your unit that are unreasonable to continue because it would interfere with the rights of the next tenant, it may be that you have to pay to have the premises restored to the way it was prior to the modification. In order to qualify or have the right to a reasonable modification or accommodation, you must be able to show that those things are necessary and reasonable, and that there's also a nexus. And the next couple of slides will talk more about that. So what is reasonable? At least here in the Ninth Circuit, there's a burden shifting approach in determining whether an accommodation or modification is reasonable. The party requesting the accommodation or modification bears the initial burden of proof of showing that it is a reasonable request. Once that showing is made, the burden then shifts to the housing provider to disprove reasonableness. And a housing provider is required to grant the requested accommodation unless they can prove that the requested accommodation or modification is not reasonable. It should be noted, because this comes up quite often in cases, that a landlord or housing provider doesn't get to choose what accommodation or modification a person, a tenant or prospective tenant should receive. If the request of the tenant or prospective tenant is reasonable, that is the accommodation that should be provided. There's some case law on this regarding how people with disabilities are best equipped to know what works for them, and that it's not really up to a housing provider to dictate accommodations. Establishing reasonableness, you can ask 3 questions. Is the request reasonable on its face? Is it something that's common ordinarily or in the run of cases? And is it something that the housing provider can actually do without difficulty? Is it plausible? Is it within the realm of reality? Disputing reasonableness, a housing provider can refuse a requested accommodation or modification for a couple of reasons. The first, if it would constitute an undue financial or administrative burden. So some of the factors that you would look at here are the cost, the benefit to the tenant, the financial resources of the provider, the availability of equally effective, less expensive measures. It should be noted that some cost or financial burden on the provider is to be expected. And as a common example of this, if somebody's requesting that they have a designated parking space at their housing because of their disability, the cost of striping or signing that space usually would fall on on the housing provider. This would be considered an accommodation. And it's a minimal cost that should be burdened. The other reason to deny an accommodation or modification request is whether the request constitutes a fundamental alteration, meaning does the request alter the essential nature of the housing provider's operations? And for an example, it would be a fundamental alteration to ask an on-site manager to drive you to the store as a housing accommodation, because it really has nothing to do with your housing, and it's not something that a housing provider ordinarily does. Whereas it would not be a fundamental alteration to ask that on-site manager hold mail for you at the rental office because the mailboxes are inaccessible to you, because that's more in line with what the housing provider can do. When you're looking at the necessary prong of the test, you ask the following questions. Does the provision of the accommodation promote equal opportunity for the individual to use and enjoy his or her housing? And or will the accommodation enhance the individual's quality of life by lessening the effects of his or her disability? When we talk about a nexus being required or a connection, there must be a connection between the tenant's disability and the requested accommodation and their ability to use or enjoy their housing. If a tenant's disability is not obvious or readily apparent, a housing provider may ask for documentation to support the accommodation or modification request. A tenant or resident is not required to disclose their specific disability. They need only disclose enough information to document the fact that they have a disability and that they have a disability related need for what they're requesting. Reliable documentation of an individual's disability or need for accommodation or modification can include their own credible statements or documents from medical professionals, social workers, family members, or documentation of receipt of disability benefits. And this is really something that is evaluated on a case-by-case basis. So here's an example of where there's a nexus and no nexus. A tenant whose disability is exacerbated by loud noises requests a transfer to a quieter unit and the ability to install soundproofing. It's clear that what they're requesting is related to their disability and their ability to use or enjoy their housing. A tenant's disability is exacerbated by loud noises and they request an accessible parking space. That doesn't really seem to line up. And that's a situation where there may be some questions from the housing provider on how is this related? What does an accessible parking space have to do with the fact that your disability is exacerbated by loud noises? So that leads us to the concept of the interactive process. When a housing provider refuses a requested accommodation or modification because it's not reasonable or because they perceive it not to be reasonable, the provider should discuss with the requester whether there are alternatives that would effectively address the requester's disability needs, or otherwise ask questions to clarify the situation. And individuals with disabilities should be available and willing to engage in such a process, particularly if their disability or the need for accommodation is not obvious. So basically, talk it out. There's an obligation on both sides to talk it out. A couple of fair housing cases on the interactive process that I wanted to highlight, and these are really relevant to folks who are in California. The first is Howard versus HMK Holdings. This is a Ninth Circuit appellate case that held that there's no standalone liability for the failure to engage in an interactive process. So I should note that the Fair Housing Act itself and its regulations don't expressly require an interactive process. But materials from the Department of Justice and from the Department of Housing and Urban Development do suggest that that's something that folks should engage in. So in some circuits, the courts have held that it's mandatory. In the Ninth Circuit, we haven't had that body of case law. But again, Howard and HMK Holdings only holds that there's no standalone liability for failure to engage in an interactive process, meaning you can't sue a landlord solely for the failure to engage in an interactive process. However, there's other cases. Rodriguez v. Morgan is one. And there's also Smith versus Powdrill, I believe is the name, that's not listed here. And those cases hold that the failure to engage in an interactive process is still something that you can consider in determining whether a housing provider has failed to accommodate somebody. So it may not be a standalone claim, but it still is relevant and should be factored in when the courts are determining whether or not somebody's right to reasonable accommodation or modification has been violated. And then the last bullet here is just with a typo, the HUD and DOJ joint statement on reasonable accommodations and modifications use language, you should use an interactive process. So those are guidance for this. And here are the here are links to the joint statements, both on reasonable accommodations and reasonable modifications. When you get this PowerPoint after the presentation, these should be active links. You'll be able to link to those. They're in question and answer format. If you haven't seen them already, they are very, very useful. They can be cited in advocacy that you're doing, whether it's court advocacy or just writing letters on behalf of tenants or advocating for yourself. Very easy to understand format. I did want to include one slide on design and construction, although that could be its own, 2-day training. So under the Fair Housing Act, housing built for first occupancy after March 1991 must include a number of accessibility features that are listed here. Public and common use areas that are readily accessible to and usable by people with disabilities, doors that are designed to allow people to get in and throughout their premises, their covered dwellings, an accessible route into and through the dwelling unit, light switches and electrical outlets, environmental controls that are accessible, reinforcements in bathroom walls to allow people to install grab bars where necessary, and usable kitchens and bathrooms that usually requires certain amounts of clearance for someone who uses a wheelchair to be able to get in, turn around, and use all the amenities. There is a joint statement on accessibility requirements as well, and that's linked there. And then for people who are particularly interested in this issue, the Fair Housing Center of Metropolitan Detroit has a video on YouTube that is focused on design and construction, and I provide a link there. It's an hour long, it's quite good, so I encourage people to take a look at it. The Fair Housing Act has really broad standing. Anyone aggrieved by a discriminatory housing practice has the right to enforce the law. So this would include anyone who claims to be injured by discriminatory housing practice or believes that they will be injured by a discriminatory housing practice that's about to occur. So standing to sue or to enforce the act has been extended to people with disabilities themselves, people associated with folks with disabilities, a parent, a friend, a spouse, fair housing organizations representing people with disabilities, and housing providers that have been prevented from building or operating housing that serves people with disabilities, including things like sober living homes or group homes. In terms of enforcement, the Department of Housing and Urban Development is in charge of enforcing the Fair Housing Act. There's a link there for how to file a complaint. Complaints must be filed within 1 year. HUD must complete an investigation and make a determination of reasonable cause within 100 days. If they don't meet that deadline, they're supposed to notify the complainant in writing. While HUD is conducting their investigation, the statute of limitations for filing a lawsuit is tolled or paused. And then it's important to know that filing a complaint with HUD is not a prerequisite for filing suit on fair housing claims. This is not the same as, say, employment procedures where you have to exhaust administrative proceedings before going to court. And fair housing claims generally have a 2-year statute of limitations. Kinds of remedies you can receive through a HUD complaint: non-monetary relief, correction of the illegal behavior, the end of the discriminatory policy. You can ask for new discriminatory policies to be developed, data reporting, things like that. Compensatory relief, economic damages or out-of-pocket costs, and compensation for emotional damages. There's punitive damages, damages intended to punish the housing provider where there's been particularly egregious behavior or intentional behavior. And then you can recover attorney's fees and filing costs. Final slide on the Fair Housing Act. It also prohibits retaliation. So if somebody is asserting their fair housing rights or helping another in asserting their fair housing rights, it's unlawful for a housing provider or other person to coerce, intimidate, threaten, or interfere with you in doing that. I did want to put in here a couple of slides on California's law, which differs slightly from the Fair Housing Act in a good way. California's Fair Employment and Housing Act, or FEHA, prohibits discrimination in the sale, rental, and financing of dwellings. It basically tracks the scope of coverage under and prohibitions under the Fair Housing Act. It has similar provisions for reasonable accommodations and modifications. I provide a cite on this particular slide to somewhat recently updated regulations, FEHA regulations, which detail reasonable accommodation, modification rights and responsibilities. There are some differences between the two acts related to disability. The FEHA definition of disability requires only that a major life activity be limited, not substantially limited. Mitigating measures are not considered in assessing whether somebody has a disability, like corrective measures that people can take on their own. FEHA also prohibits discrimination on the basis of medical condition, which is defined as meaning any health impairment related to or associated with a diagnosis of cancer or record or history of cancer or genetic characteristics. And I know that Hillary put this also in the chat. Other differences between FEHA and the Fair Housing Act, the regulations, the new regulations for FEHA clarify that the interactive process is required for requests for reasonable accommodations and modifications. So in this way, it's a lot stronger than the Fair Housing Act. If a housing provider fails to engage in an interactive process with a tenant, that's something that violates the regulations. And the purpose of the interactive process is to, again, exchange information to identify, evaluate, and implement a reasonable modification that allows someone to use and enjoy their housing. And if a housing provider believes that they can't grant a request, it is really on them to raise that with the requester and to figure out if there's an alternative that would work. The California regulations also clarify a number of times where the cost for modifications, which again ordinarily fall on a tenant unless you're talking about public housing, can be shifted to a housing provider. And for example, if a housing provider failed to comply with building or accessibility codes at the time of construction, and that results in a barrier and need for modification for a tenant, the tenant is able to say, hey, housing provider, you didn't do it the right way when you constructed the building, so you have to do that now. My need for modification is the result of you're not following the codes, so I shouldn't have to pay for that, you should. And that does make sense. And then also a housing provider will be responsible for paying for modifications that result from their failure to maintain their property and maintain accessible features. The one other thing that I wanted to note about California law is that it prohibits source of income discrimination, which includes Section 8 subsidies. That's something that's not prohibited under the federal law. And I noted in a disability presentation because people with disabilities are disproportionately represented in the community of people who receive Section 8 benefits due to some of those economic disparities that I noted at the beginning of the presentation. Enforcement of FEHA falls under the purview of the California Civil Rights Department, formerly known as the Department of Fair Employment and Housing. Again, similar to HUD complaints, complaint has to be filed within a year. There's a link there for their online complaint process, which is quite intuitive to do. And then CRD must complete their investigation and make a determination within 100 days. Similar to HUD, if they don't meet that deadline, they have to notify complainants in writing, explaining the reasons for the delay. Statute of limitations is also told here while CRD is conducting their investigation. And a CRD complaint is not a prerequisite for filing suit on FEHA claims. And FEHA claims also have a 2-year statute of limitations generally. Remedies here, excuse me. Remedies here are similar to the remedies available under the Fair Housing Act. Injunctive relief that can correct the illegal behavior and discriminatory policies or mandate new policies, compensatory damages, punitive damages, recovery of fees and filing costs. And the injunctive relief, I have to say, is also very case specific. The courts in particular have a lot of discretion on what they can order to tailor discrimination that has occurred. But typically in fair housing cases, I would say that policy development, having the housing providers submit themselves and their employees to fair housing training, some sort of data collection and reporting, those are things that you usually see. Oh, and affirmative advertising as well. And under the state law, there's also a retaliation provision. So you can't retaliate against people who are asserting their rights or assisting others in asserting their rights under the state fair housing law. I wanted to do a couple of hypotheticals and would encourage people to throw ideas in the chat as we go through these. So the first one, Juan has cerebral palsy. He moves into an apartment. He advises the landlord that he needs to have reinforcements and grab bars installed in the shower. The landlord says there's no way he's paying for this and tells Juan he can have the reinforcements and grab bars installed, but at his own expense. Is this discriminatory? What are folks' thoughts on that in the chat? Anyone? Yes. Okay. So we got a couple of answers, and they were either no, it's not discriminatory because the landlord is allowing Juan to make the modification at his own expense. And then a number of people saying, well, it depends. Is this public housing? And the answer is it depends, because we don't know what type of housing this is. We also don't know when the housing was constructed, which may make a difference if this is in California. So if this is public housing, the housing provider would have to pay, right? But if this is private housing, then the modification may be at Juan's expense. Next hypothetical. Miko has physical disabilities that make it difficult and painful to navigate stairs, including stairs leading in and out of the pool at her apartment complex. The pool has a lift that Miko has used consistently over the years, but a few months ago, the lift broke. Management has told Miko that they do not have the funds to pay for the lift to be repaired or replaced. Management tells Miko that they will permit her to replace the lift at her own expense as a reasonable modification for her disability. Now let's assume this is private housing. Is this discriminatory? And if you're answering yes, let me know why. Right. So the folks answering in the chat are saying it is the landlord's responsibility because it's in a common area, which is correct. It's a common area. It's a accessibility feature that the housing provider has an obligation to maintain. So especially under California law, this is really clear. If the housing provider, if the lack of access is due to the housing provider's failure to maintain an accessible feature, it can be the housing provider's responsibility to pay, not the tenant. Stacy is a person living with HIV. She applies to rent an apartment and discloses this information to the manager. The manager replies that he will rent her the apartment, but only if she agrees not to use the pool because he does not want other tenants exposed to the virus. Stacy explains to the manager that there is no risk of transmission from swimming in a pool. However, the manager decides not to rent to her because she is a direct threat to other tenants. Has the manager engaged in discrimination? Right. So everybody has got this one right. So absolutely, this is discrimination. HIV is not transmitted through a pool. There's no individualized assessment here. She's not a direct threat. Good job. Yes, absolutely. It's discrimination based on an assumption or a stereotype. Okay, next hypothetical, and I think this might be the last one. No, there's one more after this. An apartment complex has strict rules that no pets are allowed. However, a blind tenant has a service dog in her unit. Another tenant sees the dog and tells management that he would also like to have a dog. The manager tells the tenant no and warns that if he gets a dog, he will be served with an eviction notice. Has the tenant requesting the dog been discriminated against? Answer that first one part. Right. So if the tenant who's requesting the dog, because yes, good, Colleen got it. Does this other tenant have a disability? We don't know. So maybe it really depends. If the other tenant does not have a disability and just wants to get a dog because he sees that the other tenant has a dog, that's not discrimination. Housing providers can still have no pet policies. Second part of the hypo. The landlord also then tells the blind tenant that he can no longer keep a service dog because it has opened the floodgates to requests from other tenants. Is the landlord justified? Yes, that's discrimination. Everybody's got that one right. You cannot deny an accommodation request because you fear it will lead to other accommodation requests. So even if the housing was 50% people who were blind or low vision, and they all wanted to ask for service animals, each person's request has to be looked at and assessed individually. You can't say no based on this floodgates kind of argument, though people make that argument all the time. All right, here's, I believe, the last hypothetical. Jamal has an emotional support cat. Jamal applies to rent an apartment after doing a walkthrough with the on-site manager. Jamal includes on his application that he has an emotional support cat. The on-site manager texts Jamal to say, it's our policy not to accept cats, even emotional support cats. Jamal files a complaint with the California Civil Rights Department. The on-site manager tells the Civil Rights Department investigator that Jamal did not look disabled or provide her with any information about his disability. Would the Civil Rights Department be justified in closing Jamal's complaint? Right, so the complaint is valid. It looks like everyone responding has the same idea. Right, so the housing provider here has expressed a discriminatory policy, right? They are saying basically, we're not accepting cats, even if emotional support cats, which sends the message, we aren't going to accommodate you. Does it matter that Jamal did not look disabled or provide any information about his disability? Was that his obligation to do that? That's a good question, right? The housing provider should have engaged in an interactive process, but what if they just have a flat policy of discriminating? The tenant doesn't have to volunteer additional information when they've already had the door closed in their face, right? So I would push back on that as well. I did not have any more slides. I will mention that last hypothetical is based on a case that I had that just won a trial decision on that last week. And we'll probably discuss that in more detail at next week's training, which I'm co-presenting with, I can't remember which training it is, but it's dealing with source of income discrimination and assistance dog issues in particular. So I encourage people to join us again next week at noon to discuss those two issues. And then on the 21st, there's another presentation. That one is focusing on using fair housing law to avoid adverse housing actions like eviction. So we have about 10-12 minutes left. I will stop sharing my screen and take a look at the Q&A. So if people have questions. Oh, I'm sorry, go ahead.
Sorry, Michelle. We have a question on the chat. Somebody asked, could you expand on the Mrs. Murphy exception in California?
Sure. So if somebody owns a 4-unit or less housing complex and occupies one of the units themselves, then the Fair Housing Act would not apply to that situation, with the exception again of advertising provisions. I've never seen that come up though. I'm interested if other people have actually had that exception come into play. And I really haven't had even the single family home issues come into play because most people are at this point in time rent and advertise their available single family homes with the aid of real estate agents and things like that, which takes them out of the exception. So moving to the, let's see, we have some questions. Somebody's asking, in circumstances where housing is designated only for tenants with disabilities, for example, cerebral palsy, can the management company ask for medical information to confirm the disability? I would believe the answer is yes, to show that you qualify for that particular designated housing, that you could be asked to provide information confirming your disability and availability. And if there was housing particular for people with HIV, for example, you have to be able to prove that you're someone who qualifies for that housing. Maria asks, where do private condo developments who do not receive federal funds fall within the FHA in terms of being able to allow a resident to install a ramp? If it's a private condo development, the you do the analysis for reasonable modification with a private entity. So it would be on the tenant to pay for the ramp, but the condo association would not have the ability to block that from happening if it's reasonable to happen. So people often request for things like that. Some condo associations have common areas where there's no curb cuts, for example. And I've worked with tenants who've gone through the process of requesting the ability to install a curb ramp so they can get from their car to their unit. And it was at their expense. One thing to be wary of, I guess, with the with homeowners associations and condo associations is that oftentimes they have processes that they want people to follow to request modifications and accommodations, where they have meetings where people who are not decision makers are privy to the requests. I worked with one tenant whose condo association required him to go door to door to everybody else in the complex to get them to sign off on his request for an accommodation. And his accommodation actually was due to a mental health disability. So it was particularly egregious that he had to go door to door to his neighbors to disclose that he had a disability and needed an accommodation. So those kind of things, condo associations just are notorious for not understanding confidentiality and understanding their obligations. Matthew asks for an example of how the Fair Housing Act can be utilized as a defense to eviction. We will talk about that more on the 21st, but just as one example, if somebody, I once had a tenant who had night terrors. He would wake up in the middle of the night screaming. He was interfering, reasonably so, with the quiet enjoyment of his neighbors who shared walls with him. We used the Fair Housing Act in that situation. He was able to get approval to do modifications to his unit that would install soundproofing on the walls. And he was able to get a veterans organization to help in paying for that to be done. And that the housing provider had to allow him to do that. It wasn't a fundamental alteration. It wasn't an undue burden on them. And that mitigated the impact of the night terrors on the neighbors. So he was able to maintain his housing. Jennifer asks, what if smoking helps to relieve the tenant from symptoms related to her disability? You know, that issue has come up before. That's a really sticky issue because it just is, because the smoking really irritates other people. I am aware of tenants that have asked landlords to designate smoking areas in their complex. Smoking in the unit oftentimes is just not going to be seen as an accommodation, even if you have an argument that the smoking is related to, you know, for example, a mental health disability, or somebody who's recovering from some kind of addiction issue. Designating an area for the person to smoke may work. It depends on the layout of the housing, but I don't know about that particular accommodation request. And we have about 4 minutes. I think I answered that one. Let's see, Nancy. Can a tenant who is blind request as an accommodation to have someone help fill out their rent application? Yes, that's kind of a textbook type of accommodation. That shouldn't be a problem. Yes, that should be an accommodation granted by a housing provider or a rental agent or whoever. If somebody is blind and needs assistance filling out an application, they should be able to get that. Thank you for asking that question. I'm just going to go to the chat real quick to see if there's.
I was going to say, yeah, we have a couple more questions in the chat.
And if I don't get to these questions, I don't know, Diana, is there a way to capture the chat so then I can send people answers via email?
Absolutely.
People are also encouraged to contact me. Again, we're a support center. My presentation, I'm sure, was terribly boring, but I've been doing fair housing litigation for about 30 years and probably have the answers or know somebody who has the answers to most of these questions. How does the Fair Housing Act apply to a homeless shelter? Homeless shelters are also covered by the ADA, I have to say, and maybe even sometimes by Section 504 if they receive federal funding. But homeless shelters are recognized as being housing covered by the Fair Housing Act. I don't know exactly what your question is, but it does apply to homeless shelters. So people with disabilities cannot be discriminated against in the housing, in homeless shelters. I did a case at one point involving a service animal ban at housing shelters in the city of LA, where they just would not allow anybody in with their animals and would try to separate them. And for people who had legitimate service animals, that was a real problem. They couldn't use the shelter without being able to go in with their service animals. That is discrimination under the Fair Housing Act, also under the ADA. I know other people have had issues with homeless shelters as well, but homeless shelters do have to provide accommodations as necessary to people with disabilities. I think that gets us right. Well, my watch may be off. I think we have 2 more minutes.
We have 3 minutes left.
Let me see. Is there a timeline or time limit for reasonable accommodation or modification to be denied or approved? There's no bright line answer. It really depends on, the housing provider, what you're requesting, whether there has to be some levels of approval or analysis or what have you. But if you're asking for something like, I was diagnosed with depression, I'd like to get an emotional support cat. It was recommended by my doctor. Should not take 6 months for a housing provider to respond to that kind of request. That's the kind of request that should be immediately answered, or at the most, 2 weeks or 3 weeks. So that, but if you're asking to do substantial construction in common areas of a property to accommodate your disability, installing a ramp, doing curb cuts, the housing provider may and would be within their right to ask for some blueprints to kind of engage in a discussion with you about what exactly you're trying to do, make sure you get the right permits. That's a more long process. So it's really on a case-by-case basis. And then Lisa, how does the Fair Housing Act come into play in nursing homes or assisted living facilities? It applies the same way that it applies to homeless shelters and other dwellings. People with disabilities have the right to reasonable modifications and accommodations. Assisted living facilities often will try to ban motorized wheelchairs or will refuse to provide specialized diets for someone who has like celiac disease. Oftentimes assisted living facilities and nursing homes have inaccessible restrooms and force people to use bedpans and things like that when they are otherwise independent and able to use a restroom that's properly constructed. So yeah, those types of things are illegal under both the Fair Housing Act and other laws that apply in those kinds of situations, including the ADA and Section 504. I think that's probably all I have to do. I will note that Diana put the link to the evaluation in the chat. I will send out the PowerPoint later today to everyone who was on our registration list, to the emails that were provided, and do encourage people. I'm so sorry. I should have a cup of coffee here with me. I keep coughing. But I encourage people to reach out to me if you have questions or want to collaborate on something. I'm always happy to make new connections. And I really appreciate people coming. I know it's Passover and Good Friday and also just Friday. So have a great weekend and appreciate you all.
Thank you, Michelle. Thank you everyone for participating, and we will see you next week.